Okay, I think we're good.
Okay. Well, hello, everybody, and thank you so much for reconvening to look at Nicole's most recent handiwork that she worked in the wee hours, I think, of last night to get to us. I appreciate it.
I'm sorry about that.
No, it's great. It's fresh in my mind. But anyway, I wanted to start with, first of all, reading the conflict statement and then determining whether or not we have any conflict.
Hold on, Dion.
Okay.
Is anybody else getting feedback? I am.
I mean, put your microphone on mute. That might be what's causing it, Nicole.
Okay, can you hear me now? Is that better? Okay. So members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any manner or any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. So with that said, I think we have some guests that maybe Nicole could, if you know who they are, and you can introduce them, or they can introduce themselves. I see perhaps our namesake, the reason that we're meeting with Reggie. So if we can just have those who are joining us for the first time introduce themselves, and I'll go on mute for now.
Nicole, do you want me to begin? I don't know. Okay. So my name is Reggie O'Rourke. I serve as Associate Counsel of the North Carolina Guardian Light Program, and I'm grateful that this subcommittee has been convened to answer the ethics questions that I presented. And also joining with us is Lori Dollar. She is the administrator of the Guardian Light Program, so she is my boss, and she's in charge of the program. And I don't know anyone else who's joining us. But thank you very much for allowing me to be here. Thank you very much for entertaining the questions, and thanks, Nicole, for drafting what you drafted so far. So thank you.
Thanks so much, Reggie, and hello, Lori. We're happy to have you guys here. We know that your comments are going to help us figure out which opinion we should go with and whether or not we need to make additions to the opinions. Nicole, could you lead us through the differences between now? I guess we have the original opinion that we reviewed meeting before last, and then we have two fresh new looks at it. One of them we anticipated, which would incorporate some of the discussion that we had about NRA RD, and then the other is looking at more of a policy ability to get through not having testimony.
Yes. So in the first draft, I prepared it just strictly from the Rule 3.7 and said the answer is no, the lawyer can't testify if the lawyer is going to also be the advocate for the juvenile. After our subcommittee meeting, which seems like a very long time ago, it was probably like 3 months ago, it's been a long time, but you directed me to prepare 2 more drafts of the opinion, one that would rely on the Supreme Court case that Mr. O'Rourke brought to our attention, NRA RD, which is a termination of parental rights case, but that in that case, the Supreme Court held that it was okay for a lawyer who was appointed as both the GAL and the advocate to submit a report and not testify. And what happened in that case is the trial court, recognizing that the lawyer would have a conflict of interest under Rule 3.7, which is the lawyer as a witness rule that says that a lawyer can't be a witness unless one of those 3 exceptions applies, and also serve as the advocate. So the trial court gave the lawyer the option. You can either submit your GAL report and not testify, or you can withdraw as counsel and testify. So the lawyer opted to not testify. So I prepared an opinion that focuses on that holding and that allows the lawyer to be able to prepare the report, but then not testify. I did have some struggles with that because in the Supreme Court case, it references the best interest phase and it not being litigious. And I'm just not sure if that really happens in DSS cases. So I'm not sure that the Supreme Court decision is really the best option, but I'll let all of you decide that, of course. And then the third option discusses, I tried to fit it into the exception under Rule 3.7 that state says that a lawyer can testify if withdrawal would work a substantial hardship on the client. So I took it from that perspective. I could not find any support in any other state that applied that exception. All of the opinions that I found said that unless withdrawal would work a substantial hardship, but there was no analysis on what constitutes a substantial hardship, except I did find one case where the court said, or not the court, but the state bar, the ethics committee said that a financial detriment is not reason enough to work a substantial hardship. So there is nothing out there really to support this third option, but I put that out there for you all to review and look at. What we talked about in the last subcommittee meeting was that application of 3.7 in its strictest perspective is not feasible because of how DSS court works and the impact that it would have on AOC's budget and whether or not there would be enough lawyers to be able to volunteer and to participate. So I think I said in my email that I need, if we decide to go with that third option, then I need more help from those of you who do this kind of work to fill in the facts of how DSS court works and why this would work a substantial hardship if the lawyer would have to withdraw as advocate and not be able to testify. So that's where we are.
Okay, thanks for that summary. I guess if we can just open it up and hear what the subcommittee thinks about which or either of these rewrites, whether we like them better, questions we may have associated with them. So I have a few comments, but I'm going to wait and hear what everyone has to say.
So Dorothy has her hand raised.
So I have a couple of comments too about number 3, especially and I get why you said that, Nicole, as far as like not knowing how the courtroom works and stuff. And I have some comments to that. But before I get to that, can we be reminded why we were considering the impact that it would have on AOC's budget and like all of that good stuff, and why we didn't, or maybe this discussion took place before I came onto the committee about why it couldn't just be that 2 attorneys would get appointed. Like why we couldn't have one attorney as the GAL advocate and then GAL and then one as the attorney advocate. So can we just get like,
Nicole, I'm happy to answer it because Dorothy wasn't in the meeting that we had, and I was the one that brought it up because, Dorothy, you will not be surprised that other attorneys who do not practice in this courtroom were absolutely they were quite upset about some of the rules that actually occur, like getting a court report on the same day and having to automatically prepare and go to trial, right? There's some issues, frankly, that you and I have talked about and wish we could change. But the reason why, which I stand by, and I think solidly, Nicole is right, that I think opinion 1 should be the opinion. But what we talked about in that meeting is that as of right now, the way that it works in juvenile court is that AOC has a certain amount of money that they are given, and that because in every single private TPR that you would have, which Wake County, to be clear, has started to do since I brought this to their attention. The judge is appointing an attorney as the volunteer and an attorney as the attorney advocate.
Right.
Now, and which should be the process.
Right.
The issue ultimately came down to it would be a burden financially for you to have two attorneys getting paid to fulfill the requirements of the professional rules of conduct on opinion 1 that Nicole wrote. And then the other is in some areas, they don't have a lot of attorneys. So what would you do if you didn't have a significant amount of attorneys who could actually be there to then have the attorney advocate and then also the volunteer? But the summation was basically it came down to finances. Is that fair to say, Nicole and Dion and Lloyd and Gina?
Yes.
Okay.
Thank you.
Okay, because I mean, yeah, what you said is exactly what I mean. To me, what makes sense on why to solve all of this is just to have the two appointed and be done with it. Okay, so yeah, I'll wait for other discussion on the rest of that then, because I do have some comments on that number 3, especially as it relates to how it all happens in the courtroom and the process and all of that good stuff.
And Nicole, I will interject. Number 2, I think with your opinion too about the Supreme Court, it's an adversarial process. The entire process is adversarial.
It
I
seems
disagree.
that way to me, but
I mean, I know that they said it, but if your rights are about to be terminated, right, and you're in a hearing and you can cross-examine people, and this is the only thing stopping me from having my rights terminated, it's an adversarial process. No one who's ever been in that hearing or in that courtroom would say best interest is not adversarial. And I think that the problem with number 2, which is also the same theme that goes through all of them, is that if you write a court report, you're necessarily making yourself a witness.
Absolutely.
And I think that it is unfair for any party to not cross-examine a GAL that can put whatever they want in a report and then just be silent instead of advocating. So that is the struggle that I have, is because when you're looking at justice and fairness, it is not fair for anyone to be able to put evidence forward and then not be cross-examined on that.
I totally agree. And that's some of the concerns I have about number 3 as well, where it speaks about if the court report contain statements by other witnesses. Well, here's the part. If one of the parties gives false testimony, the GAL attorney advocate is the one person equipped with all the relevant information and therefore is in the best position to rebut false testimony. I wouldn't necessarily agree with that. And also this likewise, additionally, if one of the parents' attorney objects to a statement made by another witness who is not present in the court to be cross-examined, it is once again up to the GAL attorney advocate to provide the court with the relevant facts and explain the absent witness's statement. I think Sydney has summed it up best by saying that it is an adversarial process. And I would submit, if even me as a guardian ad litem in other kinds of cases, I expect to be cross-examined. I expect to be called as a witness about any of these things, not necessarily just to advocate or be the best person to rebut these things, but just because it may just be you want more clarification on something. I mean, even if we took it away from the completely adversarial side, it may just be for clarification or something like that. But yeah, I struggle with that too.
Does Jack have a comment?
We can't hear you.
Unmute.
Jack, you're on mute. Yeah.
No, I don't think he's muted. I think it might be his he might not have his audio connected because he's not there. You are. Yeah, well. And too, Nicole, while he's pulling it up, it could be anybody objects to the statements, not just the parent attorney, but
Okay.
you know.
And Nicole, and for background, by way of background for everyone, when you're in a hearing, it's not, so there are other witnesses that are called. Sometimes it's just the petitioner, sometimes it's the respondent, but you could call a grandmother, you can call the child's therapist, you can call the parent's substance abuse counselor. And so if the guardian ad litem, when I write my reports up, it basically it summarizes my investigation and what's happened. But if I transpose a number or if I get something inaccurate, right, then and the report comes in and I can't testify or clarify it, or frankly, no one can clarify it, and it was just a just harmless error, but it's substantive, no one would be able to question me about that, which again, I mean, I think we're not always the best people, in my opinion, as important as I think guardian ad litems are for children. We're not always the people that have the most information, right? A child's therapist is going to be in a better position to be able to testify about the child's diagnosis than me trying to be a, Monday morning quarterback, figuring out what happened where I don't have the degree to be able to say, this child has this, and this is what
So
happened.
are all those people there in court? Because I thought my notes indicate from our last meeting is that no one is there other than the parents. So I guess I
It
got that
depends.
wrong, but
It depends. They could have been subpoenaed to court, or they could have not been subpoenaed and you just have them and they agreed to be a witness.
okay.
So, yeah, they could be there for sure.
So, I mean, we've had, and Nicole, as by way of example, I've had an 8-day termination of parental rights hearing where we had probably 9 witnesses,
Okay.
right? So or you could have one that's a half an hour and the only person who testifies is the petitioner. So there's a wide range of the advocacy that all the parties have at the table and the need for certain witnesses.
And I would submit too, like what Sydney said earlier, that a lot of times we see the best interest phase as being the most adversarial, because more likely than not, I mean, they only have to meet one ground in order to move from what we call the grounds phase or adjudication phase to best interest. So once that, and it's usually a pretty extensive amount of evidence or that is presented to meet one or more than one ground. So once that is met, then you move to best interest. And that for us as parents attorneys, especially, that's when we really can make some, segue, some really strong arguments, presenting a lot of evidence to, speak about or have people speak about the bond that is in place, why, even though judge, you may have found this ground, this is why it's not in this child's best interest to terminate. You know what I mean? So really, to me, I see it as more adversarial than the grounds phase.
And to be clear, Dorothy and I will have a lot to say, so people should just interject, because I'm pretty sure she and I are probably on the same page about opinion 2 and 3, where I have notes, but I've talked a lot, so I'm going to remain quiet so everybody else can say something.
I just had a question. If we went back to the original opinion, the way that looked was that it gave the possibility of preparing the report, assuming that there could be a time when you would prepare the report, but not find that you yourself would be a necessary witness. And is that even something that you guys think would ever be the case? Because that's sort of the way it was written, is you can do it, but if you think you're going to be a necessary witness, then you withdraw, right?
I think that is the way that's written. I don't think that anybody should ever write a report expected to present it and not see themselves as a necessary witness in this situation.
I think that was one of the concerns too, is, are we, that by suggesting that that's an option, are we suggesting that people fudge on that by saying when it's really should never be a situation where, it's like it's suggestive that, I don't know how you would ever think the report would not put you in a situation where you would
Exactly
testify. Unless
you can do your own analysis all day long and think that you're not going to be a witness, but someone else calls you.
Well, I think, Deanna, it goes right. And I think it goes to the point which Nicole had mentioned before, which is, as an attorney advocate, I can call witnesses. So I can call the mom to the stand. I as a guardian ad litem volunteer and attorney advocate, I go to the house, I talk to the kids, I see the house, I talk to the parents, I talk to all other people that are relevant, talk to the child's therapist. Nothing stops me as the guardian ad litem attorney advocate from basically issuing subpoenas or asking for those individuals to come to court and me cross-examining them at best interest phase. Because of efficiency, I think, and because the rules of evidence are relaxed at best interest, and so therefore they aren't strictly adhered to, and it just has to be relevant and reliable, people don't always call witnesses. But there is a way to still be the attorney advocate, get the information that you need to advocate for what you think is best for the child, and it not come from your own testimony.
In that situation, though, you wouldn't do a report either, because that would be prejudicial and wouldn't be cross-examinable, but actually being the attorney and the attorney advocate, you would just get your evidence on the way that we always do, which is through the other witnesses. You just wouldn't have that opinion piece that you kind of can put in there, like in the NRARD, where it was sort of I think that the adoption agency petitioners were saying that the guardian ad litem is sort of like an expert witness, and the judge sort of refuted that. But there is that little bit of an opinion piece that I think is present with a GAL and a GAL report or a GAL testimony.
I know we're focusing on the role of the GAL advocate, but what would be the point of somebody being the GAL, the volunteer GAL, and not be able to give that report?
And that's frankly the magic sauce of a guardian ad litem. Like, they're the person who's going to say, hey, you know what, I've got a 6-year-old who I've talked to. Like, I mean, I can't tell you the number of kids that I've represented who are able to articulate why they do or do not want their parents' rights terminated. And I can share that with the court so that a 6-year-old doesn't have to come and testify in chambers to the judge. So it seems like if you had that role, just like the model that you have with the guardian ad litem program, where they have a volunteer and then they have an attorney advocate, you can get the best of both worlds. It's just going to cost more money.
Right. And I'm trying to understand why we just, I'm just taken aback by the fact that this is the area where we're deciding this, we're trying to save that. You know what I mean? Like, I think there's other areas that we could look to try to save money. This one is too risky.
Probably would also have a manpower problem in the far east and far west reaches of our state. I mean, this is typically not an area. I'm in Mecklenburg, so we have plenty of people who will volunteer to do this work, but I don't think it's that common other places. When I've told people before that I do GAL work, they're like, what is that? So I think it might be a funding issue, but also just be a manpower issue, that these small counties aren't going to find people who are willing to do it if you need 2 people for every case.
Can I be, am I on now?
Yes, we can hear you, Jack. Well, Jack, before you talk,
Yeah.
You guys see the remaining meeting time counting down there. This is my fault. I forgot to get Nicole a license before this meeting started. So I was going to send you all a response email to Nicole's email that she sent yesterday with a new link. If we can hop off there and jump on there, then we'll have as much time and we won't be time limited. So hold on to your thought, Jack. I'm hitting
No problem.
sending the email now, and let's all meet in the other room using the link that should be in your inbox.
Okay.
Thanks, everyone. Sorry about the